This next panel, proposed changes to European trademark law, as I understand it, is really timely. A lot is going on over here. And our moderator and sponsor as well for this event is Nick Bolter, who is the partner in charge of the Edwards, Wildman, and Palmer office here in London, and who is a specialist in trademark and copyright and other related areas of intellectual property law. And has just been a delightful addition to our program and our planning, and we're grateful to have him with us today. So Nick, please take it away.
Thank you very much. So this is your final panel session of today. I think the standard of panel sessions has been quite extraordinary so far, which has been great for you as an audience. Put some pressure on us, but we're very confident this topic is going to excite you. The topic is proposed changes to European trademark law. The proposals were published almost a year ago, 27th of March 2013, by the Commission, and they follow from the Max Planck Institute study on the overall functioning of the European trademark system, which is now that was published nearly 3 years ago. We have a fantastic panel. You're going to be hearing from the Commission, from OHIM, from the European Parliament, and from 2 brand owners. I'll introduce the panel to you. You'll first be hearing from Michael König from the Commission. Michael is the Deputy Head of Unit in the European Commission's Directorate General for the Internal Market and Services. He's in the unit responsible for industrial property. Michael joined the European Commission in 2001 in the DG for competition, overseeing merger control investigations in various industry sectors. He joined the Internal Market DG in 2008, and before joining the Commission, he worked for several years in the German Competition Authority, and he graduated in Law and Economics and also holds a PhD degree in competition law. You'll then be hearing from our invisible panelist, Cecilia Wikström, from the European Parliament. She is going to be speaking to us by video. Well, not live, unfortunately. As live, I think we call it. So we have a video from Cecilia. She has been a member of the European Parliament since 2009. She currently serves as a member of the Committee on Legal Affairs and the Committee on Civil Liberties, Justice and Home Affairs. Prior to joining the European Parliament, she was part of the Swedish Parliament, representing the Liberal Party. She has a degree in theology and has been a priest in the Swedish Church since 1994. Then we're going to be hearing from OHIM, João Negrão. So João is Portuguese. He holds a degree in international relations and specialist degrees in diplomacy and in the official state protocol. João has held positions within the Ministry of Foreign Affairs, General Directorate for the EU Affairs, and in the presidency of the Council of Ministers. Before joining OHIM, he worked in the Portuguese National Institute of Industrial Property, initially within the International Relations Cabinet, and from 2004 as its head of cabinet, then appointed as Director of International Relations and Promotion of Innovation. And then in 2010, João joined OHIM as the head of cabinet, and then in 2011 he became the Director of the International Cooperation and Legal Affairs Department. Then from the brand owner perspective, from IKEA, we have Gabrielle Olsson Skalin, who's also the Vice President of Inter. She's been the head of legal department within IKEA since 2008, and she leads both the two legal teams, IP and franchising, and she's responsible for the registration and handling of all of IKEA's trademarks worldwide. Her areas of expertise include franchising, licensing, distribution and supply, trademarks and other IP rights. And she has a Master of Law degree from the University of Lund and an Executive Master of Business Administration for the University of Lausanne. And then on my separate page, very helpfully rewrote her bio for me in the most immaculate handwriting. So Elena is a senior attorney at Microsoft, where she's been since 2007. She's in their trademark department, responsible for trademark policy. So she's it's obviously a great topic for her, and she's also chair of Inter's Parallel Imports Committee. She holds a degree in English and European law from Queen Mary and in intellectual property and antitrust from Franklin Pierce Law School. She has worked in a number of countries, both in-house and in private practice, for example, Colgate-Palmolive in New York and SIB Legal in Florence, where she practiced trademark copyright and unfair competition law for 4 years. So that's your panel, and we're going to be starting with Michael König from the Commission.
So thank you very much, and I'm very happy for the opportunity to present to you, in a nutshell, the proposed changes to the European trademark system. I couldn't agree more that this is a very timely moment, because in the whole process, with the adoption of the report of the Parliament that Cecilia is going to talk about in a moment, we really have reached an important milestone in this process. And it's a good time to, well, I wouldn't say to take stock already, but to see where we are. Now, I will start with the essentials of the reform package before looking a bit on what the discussion has focused on so far and where things will go, and also a bit the timeline. Maybe to start with, this is really basics, but I think it's important to recall one of the fundamental features of the trademark system in the EU, which is it being a dual system. So if you, as a brand owner, want protection of your trademark in the EU, you have a choice between either going to a national office, one or more national offices, and get a trademark protected and registered there, with the result of it being sort of protected only in the territory of this particular member state or member states, or as a possibility as well to go to the European level, to OHIM, and get a registration for a mark with an effect in the whole territory of the EU. Now, this is important because these two systems, they coexist, but of course there are interfaces between them. And many of the elements or drivers for this reform has in one way or another to do with this dual system. What's important to say, which we always and never stop to repeat, is that we at the Commission are committed to this dual system because we believe it makes sense. It helps people to protect their trademarks in a tailored manner, and therefore there is no intention whatsoever to do away with this dual system and sort of centralize everything in one or the other way. Now, some of the building blocks running up to the reform were already mentioned. The Max Planck study in 2010, 2011, which really looked very deeply into, let's say, under every stone and every article of the law that we have. But at the same time, we also conducted very extensive user consultations. And I'm also very happy that two representatives of users are here today on the panel. Why? Because it's for them that we do this reform. This is not a reform for the benefit of the European Commission, of national offices, of OHIM. I mean, this is designed to improve the situation of users. And I think it's very important to recall this overall objective throughout the process and for all actors. And we are very happy to hear any feedback in case this objective is not really pursued well in the views of the users. So this evaluation has shown that the system overall is functioning pretty well, so we don't need a complete overhaul or a revolution, how some people say it, but we need nevertheless to change a couple of things, because the system is in place for quite a while. I mean, designed in the 90s and not changed fundamentally over some time. There's also some inconsistency between, on the one hand, the regulation, which is dealing with the community trademark, and the laws that is harmonizing the national trademark laws, because in terms of timing, they came at different stages and therefore don't necessarily work very well together in all aspects. And this is a concern because, as I said, this dual system has to work together, and the two systems have to go hand in hand. for that to avoid any frictions. So the revision, tackles really both levels, the European level, the process for registering marks in Alicante, and the question of harmonizing, and to what extent harmonizing, the national laws of the individual member states. We also have an additional piece that deals in particular with the fees that have to be paid for registrations at OHIM, and I will come to this in a moment, why we also had to look into this. So really the essential drivers for the reform were, on the one hand, to modernize provisions that were outdated or features that have been overtaken by time. We want to improve overall access to trademark protection in the Union, access for users, for companies, to make it easier and less cumbersome, because trademark protection is most of the time not an activity in itself, but it supports business activity, the development of business, trying to support the marketing activities, to distinguish yourself from competitors, and therefore this process should be as least burdensome as possible in our view. And then the last point, I already mentioned this improving of the integration and coherence in this dual system, which is the special feature. Now, for each of these topics, I'd like to give you some examples. This is not exhaustive. This is a very rich package, but just to flag some of the major reform points, which are also for us the priorities, which we will seek to maintain and defend throughout the further legislative process, where we are not the only actor, as you very well know. Now, when we talk about adapting to the modern business environment, one example is that we want to do away with the requirement that a trademark has to be able to be represented graphically. This in particular to be able to much better capture sound marks, for example, where so far you had really to put down different notes or so, whereas we believe that in the modern times also representation in files, in MP3s, etc., should definitely be possible and accepted both at OHIM level but also at national level. Then obviously there has occurred quite a number of judgments and jurisprudence in the trademark area, which we believe has to be integrated, has to be reflected. One very prominent example is the so-called IP translator decision, which is about classification and the precision of classification and the reach of an application, of a trademark application, where we believe this should be clarified now really in the law. It relates partly also to the next point, which is really a key point, which is about stepping up the fight against counterfeits, which for us at the Commission is really one very important policy objective and maybe one of the really cornerstones and most important elements of this reform, where we really believe we need a major step forward. And this also because there was a judgment dealing in particular with the question of counterfeit goods in transit through the Union, where we believe that the rights of trademark owners have been sort of, well, I wouldn't say undermined, but we believe that there needs to be a certain correction. While the judgment was completely correct on the basis of the law as it stood, it nevertheless created a hole, so to speak, in our way to really fight against counterfeits that are moving through the Union. In the same context, we have also strengthened the possibilities of trademark owners to deal with counterfeit goods that are basically sent in small consignments, so to individuals, because there could be a doubt whether actually in the situation where you have just one of the two parties of a business operation being a business and the other one being an individual, whether this actually is an activity in the use of a trademark in the course of trade and gives actually a possibility to interfere, which we now propose to clarify that this is indeed the case. And to complement again, here in this context, we also expand the scope of activities, in particular to preparatory acts, so packaging, labels, producing of labels, etc., when it comes to counterfeit goods, to be able to step in really upstream when it is already visible that these goods, these counterfeit goods, are going to be circulated then on the market. Another element, which I don't want to dwell too much on, is a reform, some reforms as regards the governance of OHIM, to align this with some best practices that have been established for other EU agencies dealing with transparency and accountability. I'm also always stressing that this is not triggered by any problems that we have identified at OHIM. It is more guided by a general policy which is applied to all agencies, and where some of the practices which are already employed by OHIM are just anchored in the law. Then, when we talk about improving access, one element is to allow a more tailored trademark registration. Today, at the European level and at a number of member state systems, when you apply for a trademark, you basically can only do it for 3 classes in a go. You don't have to naturally use or declare 3 classes, but you pay for 3 classes. You get the possibility to use the trademark in 3 classes, no matter whether you intend to do so or not. And we believe that this, on the one hand, is basically not allowing, or basically selling more than you need, bundling things, and has an impact on the risk of cluttering of registers. Because if you get something for free anyway, well, then you will also register in a second class, and even if initially your business plans were not really in this area. And therefore we believe this, what we call one class per fee system or monoclass system, so you can apply and register class per class, is something that should really be the system both at the European and the national level. And this is where the question of the reform of the fees comes in, because for us it is rather obvious that if you now sort of move to this one-class system, the registration for one class cannot cost the same as the registration for 3 classes as it was today. It has to be less, and that's why we propose a resulting and a consequent lowering of the fee for one class compared to what had to be paid today. Under the heading Improving Access, for us also features the harmonization of the national laws. Because in our view, how business today more and more operate is that they go beyond borders. In the EU, the internal market is more and more a reality. So you have more and more companies who apply for trademarks in 2, 3, 4 countries. And providing for them some common rules and common principles that they face everywhere, in our view, is also a way to allow access to trademark registration and make it easier for companies to complement their business strategies they roll out also by a trademark strategy that implies several individual member states and countries. But this, of course, also plays in the overall heading of more integration and coherence in the system. As regards the harmonization of national laws, we believe that some really core features like the triggering dates when a registration is actually valid and what is the relevant dates for earlier marks, for priority, etc., should be harmonized throughout the Union, because you always have this cross interlinks between the different systems. We also believe that opposition and invalidity procedures should be, at least in a first instance, light procedures, administrative procedures, and forcing users to go to court, maybe with higher fees and needing a lawyer's representation, is not a good system which should prevail and which eases access. And that's why we propose also here to harmonize it in one way. Then there's one topic which triggered a lot of discussion, which is about the question of the ex officio examination of relative grounds. It basically boils down to the question whether offices basically automatically, when checking a registration and application, shall search for potential conflicts with prior rights in their registers and sort of stop and suspend registration if they find potentially conflicting marks. Where we believe that this, in reality, is more an obstacle to registrations than a service to right holders. And I will come to that in a minute still a little bit. Then, at the moment, there are still some differences between the national and the European law on some topics like collective marks, which so far were only in one, and now we really introduce in both systems. And last but not least, we believe that in such a dual system, one has to provide for a proper and solid cooperation mechanism, where OHIM and the national offices can work together and improve the situation for users, because we can do a lot in the law, but a lot is also in, first, the practice of offices, and this practice should be as harmonized as possible in our view. And there's a lot also in very practical issues like sharing databases, for example, which is something which we cannot do by law, but where we have to rely on OHIM and the national offices to work together. And João will definitely still be able to explain a little bit more about this important work. So that was some of the main avenues and issues that we had in our proposals, which are important for us. In the discussion between the legislators, because once our Commission proposal is out, it is both the European Parliament and the Council, which represents the member states, dealing with our proposals. And in the discussions, well, some points which didn't surprise us have become very much discussed. One is our proposal on the goods in transit, where we really opted for a very strong tool, which is a political choice, an effective tool to be able to seize counterfeit goods passing through the EU, regardless of the question of trademark protection in the country of origin or destination. But where we believe that this is the only efficient and practicable tool, because all other features and solutions just play in the hands of counterfeiters who are very good in providing all types of false information on where goods come from and go to. On the question of harmonization, well, this point on this ex officio examination of prior trademark owners' rights was very much debated. Is it a service for SMEs as right holders, or is it an obstacle for SMEs who want to get certain trademarks registered and who are faced with, let's say, registration sitting on the registers, but where the marks are either not in use, no longer in use, companies have disappeared, and it is then for the applicant to try to find the owner, get a consent, and it's impossible. Whereas when really asked, the right owner would not bother to further pursue or enforce the rights. But this is obviously a debate where, for example, the Parliament has taken the view that no, it is more a service, and therefore this possibility to examine these grounds should remain an option for national offices. The same goes, of course, always when we talk about money. That's that's an important topic. So the question on fee levels and fee structures is also very important. Here, the national offices are concerned about some competition between them and OHIM. We believe that this is a little bit over dramatized, and the basic concept of moving to a one class per fee system and then accordingly adjusting the fees makes a lot of sense. But this is obviously a very, very sensitive topic. The Parliament again followed our approach, and we'll have to see how we go on that forward. The same goes to the degree of cooperation between the different offices. How mandatory should that be, and how strongly should this be supported, is again a very important topic for us. If you say yes, we want a dual system, then you cannot say no to cooperation, to really close work together, because otherwise we really create frictions in a system which is meant for users really using a trademark protection throughout the union. Now, I also should say that we were very interested to see that there are even more features that one could reform, which also Cecilia Wikström will mention, to add to the ideas that we already had. Issues like eliminating the local address requirement for national trademark applications, or to provide more transparency on the 5-year grace period for using your trademark, which you enjoy in the EU. There's also the idea of a mediation arbitration center at OHIM, which I would be very interested to hear the users' view on, because this, as I said, was not in our remit so far. Now, where do we go from here? As I explained, the whole process starts with the Commission's proposal last year. Then the co-legislators deal with it. The Parliament now has adopted a so-called first reading report, which basically fixes their position and includes a number of proposed amendments to the Commission's proposal. Overall, we believe that this was a very positive report, which endorses many of our objectives and priorities. In some points, the Parliament didn't follow us. I mentioned this relative ground examination. We are also a bit disappointed about what they put in as regards the governance for OHIM, where they also didn't follow very much our ideas. But this we will have to see. But there, I think overall, we were pretty happy with what we saw. In the Council, the work is still ongoing. Discussions are still ongoing between the member states. Here, I have to say the approach was a little bit more hostile because member states were not very open to further harmonize their national laws, because they believe they better serve their users which are used to their system without having so much in mind users that use multiple national systems, and also have a bit of a focus on the whole financial backflows that might the whole system generate also for them. So, which is a little bit disappointing from our point of view, but we have hope that in the overall process, the main features that we have which we believe are really helpful for users, will survive. The Council has set an objective of fixing their position in May. And then, as you know, we get into a new cycle, political cycle, so the Parliament will be re-elected or new elections in May, so they will start their substantive work more in autumn, so that we will see this materializing and really going towards a final outcome more towards the end of the year, or rather beginning of next year, if the planning really works out like that. That's a bit my guess, but as usual in these processes, please don't quote me on this. I think nevertheless, I mean, a number of member states and the Italian presidency that is running the Council sort of in the second semester really has put this as a priority because they're very interested in a number of the proposals. So that's the timeline. The Commission's role there is then more that of a broker between the two institutions, where we will try to get to solutions that work for both. But this, and this is my last point, which I mentioned, I think, throughout, it's very important that the users make their voice heard in this process. Because, as I said, this is not a process and not a reform for national offices or OHIM or the European Commission, but for the users. And it's really important that their perspective and their views are really made heard in this process. So an encouragement to all practitioners and associations to really follow this very closely. Thank you.
Thank you, Mark. So we're now moving on to, hopefully somebody's going to control video and I just have to wave my hands and magically make it appear, but we're going to hear from Cecilia Wikström from the European Parliament, who's recorded a video message for us.
Dear friends, first of all, allow me to apologize for not being able to participate in person during this very interesting symposium. I would very much have liked to take the opportunity now, nevertheless, to thank the British Library, the Oxford University School of Law, and the International Trademark Association for hosting and sponsoring this event. As the rapporteur in the European Parliament for the trademark reform, I have been trying my very best to reach an agreement with the Council within the current mandate of the European Parliament. In order to be able to do this, I presented my draft report for the full trademark package by July 15th last year and managed to get the Legal Affairs to agree unanimously to a full package compromise on all aspects of the reform by Christmas. Unfortunately, the Council has needed more time and we were not able to start negotiations during this mandate. That means that the Parliament have had to adopt its position in a first reading at the last plenary session in Strasbourg. Let me tell you a few things about my basic views on this package. The trademark reform should be about evolution and not revolution. In contrast with, for example, patents, we have a European system for trademark protection which basically functions very well. There is, of course, always room for improvement, but the fundamental parts of the system work well. In this context, let me also be clear about the need to preserve and even strengthen the complementarity between the national trademark system and the European level protection. Europe has some 20 million companies. Some are large, some are small. Some companies have many trademarks, some only a few. Some companies are active in all of Europe, others only in 1 or 2 cities. The greatness of the dual system for trademark protection in Europe is that it can cater to all these companies and offer flexible and efficient solutions for the users. I am a firm believer of harmonization of the national systems in cases where this can improve the functioning and the attractiveness of the national system, but not to harmonize for the sake of harmonizing. This is, for example, why the Parliament decided to strike out the provisions in Article 4(2) of the directive on the examination of absolute grounds and why we deleted some provisions on formalities around trademarks as property objects. This is also why we introduced some additional harmonization, for example, allowing users to register marks in a national office without having to give a physical address in this country. We also asked that the start of the 5 years grace period should be entered into the register for additional legal clarity. On substantive issues, the Parliament kept this pragmatic approach with a focus on the users. We introduced a number of clarifications on exceptions to the rights granted by the mark. whilst at the same time deleting the controversial function of origin proposal from the Commission. We accepted the proposal to delete the requirement for graphical representation, but complemented the proposal with demands on the registered subject to, for instance, make sure that everything is registered with accessible technology and in a durable and precise manner. The goal is to open up for a modernization of the trademark system while at the same time maintaining registers that can be easily accessed and searched by others to determine what marks have already been registered. Another important aspect of the proposal are the proposed changes to the governance of OHIM. In the view of the Parliament, it is reasonable to update the governance of OHIM to put it in line with interinstitutional agreement on agencies, but we must do so whilst respecting the procedures which work and a reasonable balance of power between Member States, Commission and Parliament. Therefore, we have proposed rather modest but reasonable tweaks to the proposals. We believe that no institution should have potential veto rights over the appointment of the president of the agency and proposed what we believe is a balanced system geared towards finding the best candidate for the job. We also suggested that the proposed split of the board into a management board with a smaller executive board be deleted. We did not see the point with an additional level of bureaucracy. We also suggested that the 28 member states representatives and 2 commission representatives be completed by 1 representative of the directly elected European Parliament for the sake of democratic scrutiny. We also suggested to change the name of the agency. I am sorry, Antonio, but the Office for the Harmonization of the Internal Market is simply incomprehensible. We believe the office should be called the European Union Intellectual Property Agency. Although patents are managed by the EPO in Munich, the agency does have broad powers in trademarks, designs and copyright, and also host the Observatory on Counterfeiting, which covers all IP rights. Personally, I think we should work to strengthen the agency into a true IP agency of the European Union. For example, by adding the registration of geographical indicators to its duties. Although this will have to be a later political process, let's wait for the next mandate and we'll see what can be done. Let me also, in closing, mention the 2 hot potatoes on enforcement: the goods in transit and the small consignments. On small consignments, the Parliament agrees with the Commission that we need to improve the possibility to act against this. However, we believe the provision should be limited to cover only counterfeit products. A counterfeit product can pose a threat to a consumer and should be stopped. In contrast, it would not be proportional to seize a product purchased, for example, over the internet by an ordinary citizen, because this particular product was only intended for a non-European market. On transit goods, we also agree that we must act stronger than is currently possible after the Nokia Philips case. I personally do not support the line taken by a majority in the plenary of Parliament a week ago on a proposal very close to that of the Commission. It is a proposal which is, in my view, will target not only counterfeits, which we should combat, of course, but also could hit at perfectly legitimate international trade, which apparently is an acceptable collateral damage to some of my colleagues. I regret that. The only way for a non-European right holder to transit goods through with a 100% security of not having them seized in transit will be to register their marks in Europe, regardless of whether they use them here or not. This is obviously further complicated by the use requirement. Despite the assurances of the Commission and others, I doubt that this burden on our trade partners will be considered by all as compatible with our international obligations under, for example, GATT Article 5. I would instead have preferred an option which would have provided an exemption to goods which were clearly not destined for the internal market of the European Union. But given that we have not yet managed to conclude on this dossier, the debate will continue in months to come. As you know, there are elections to the European Parliament on May 25th. If I get re-elected, I hope to continue the debate and conclude on the work on this important legislative dossier together with all of you. I thank you very much for your attention and apologize yet again for not being able to participate in person in the discussions today. Thank you very much, and I wish you all the best. Bye.
So that was the Parliament, and now we get to hear from João from OHIM, or the European Union IP Agency, as they are likely to become.
From the OHIM for now. Thank you very much, Nick. And good afternoon, ladies and gentlemen. Allow me to start by thanking the McCarthy Institute for the kind invitation that you have addressed to the OHIM, and to say that it is a really great honor and pleasure to be here with all of you today to discuss such an interesting subject matter. And of course, special thanks to David and to Russ in this occasion. I think that it is important to say that, unlike the European Commission, the Parliament and the Council, we don't have a role in these negotiations. We are only the agency that applies the community trademark regulation on a daily basis. So our perspective, and therefore my presentation, needs to be a bit different from the one that we have just heard from Michael and from Cecilia, although some of the things will be, of course, in common, and I just ask you to bear with me when there is some overlap, but I think that it is necessary. Before we start, I think that it is also important to understand from where we, as an agency, come from, and of course where we are today, and what is the context in which the proposal is being put forward. 2014 marks the 20th anniversary of the Community Trademark Regulation. It was in 1994 that the regulation came into force. And for 2 decades now, we have actively supported EU industry by providing an ever-expanding range of quality services. For instance, since 1996, we have received more than 1 million community trademark applications. I don't remember because I was not there, but of course my colleagues told me that, for instance, during the first year, they expected to receive 15,000 community trademark applications. And of course they got 50,000. And that, of course, they got scared. But then, of course, they prepared the office for what was to come. And we are talking already about more than 1 million community trademark received. In 2003, we have received our first new competence, the community design. And since then until now, we have registered almost 800,000 community designs. Also, between 2004 and 2013, we have seen successive enlargements that have expanded the territorial coverage of the community trademark regulation and of the community design. And this has, of course, posed us, on an operational level, also a number of challenges. And in 2012, more recently, we have received a couple of more of new competencies. One which is very important, the EU Observatory on infringements of IP rights by a decision, by a proposal of the European Commission and a decision of the Council and of the Parliament, but also the management of the Orphan Works database, also in the area of copyright. All in all, and of course without modesty, allow me to conclude that we, of course, are focused on efficiency. Okay. And this has proved the ability, of course, to deal with new competencies. I think that the OHIM for these 20 years can be catalogued as a success story. And I think that, of course, I'm not having that much success in managing technology. I'm sorry for that. Okay. And it is in this context that I think that is normal that we ask ourselves the question, do we need to reform what already works well? Well, the Max Planck Institute said it clearly, as Michael referred, that the trademark systems in Europe, in the EU in this case, that are characterized by this coexistence between, of course, the community level and the national level, has worked well. Still also concluded that there is room for further improvement in specific areas. There is a need for further approximation of substantive provisions so as to achieve a mirroring effect between the community trademark and the trademark directive, since the first directive only aligned the most important aspects of trademark protection. There is also a need to modernize the system. I mean, the directive is from 1989. The regulation is from 1994. The world has changed very much since then. There is the advent of the internet, new business models, and so on and so forth. There is also a need to streamline and harmonize procedures by introducing key procedural rules into the directive, taking the CTM as the benchmark. And there is a need to facilitate cooperation between national offices and the OHIM by putting in place a solid cooperation framework. So my answer, of course, to the question is yes, we have done well during 20 years, but yes, we need, of course, to modernize. We need to reform. But in doing that, I also agree that, of course, we should be aiming for an evolution of the system. We should not be aiming for creating a new system. There is no need for that. There is a need to modernize, improve, and enhance the current system. And the technical proposals that have been put forward by the European Commission go exactly in that direction, in our view, in the direction of an evolution. A very important aspect of the review is the so-called mirroring effect between the regulation and the directive when it comes to substantive trademark law. Here, we don't speak anymore about mere harmonization, but rather about a single rule book with very, very few exceptions, since the quasi-totality of optional provisions in the directive have become mandatory with the proposal of the European Commission. And of course, the most important novelties in this area have been already mentioned by Michael. I will just mention a couple of them, of course: the abolishment of the graphic representation, the mandatory protection for trademarks with reputation, the requirement for clarity and precision in the designation of the goods and services following the IP translator case. And of course, I noticed that we have Richard Ashmit with us here today. And all of these provisions, of course, should apply both to the regulations and to the directive. But there are also other provisions that are relevant. For instance, the mandatory opposition and cancellation procedures in the directive to be implemented in the member states. The abolishment of searches to be replaced by modern IT tools. It does not make sense to have the same system that we have created for searches in 1994. Technology have advanced quite a lot, and we are able, of course, to provide this in a different and more effective manner. The fee structure, one class per fee system, allowing for more targeted applications per product class, both in the regulation and in the directive. And for instance, a novelty proposed also by Cecilia in her report of the European Parliament, the creation of a mediation and arbitration center. We already are today offering, within the procedures of the Boards of Appeal of the Office, mediation services. But I mean, not arbitration. This is something quite new that is stemming out from the Parliament that we understand it's quite keen on this possibility. But it is also important to see what would be the impact in our own strategy, OHIM strategy, which main goal is to develop, together with national offices of member states and with the support of the European Commission, a comprehensive and dynamic European trademark and design network. The key feature of this network is to offer as closely harmonized standards as possible in terms of processes, tools, examination practice, quality, and efficiency, in the interest of European and global consumers, trademark owners, and intellectual property specialists. There are mainly two initiatives that will facilitate the creation of such a network. The first one is a cooperation fund aiming at creating common tools to be made available to users through the national offices and the OHIM. And the other one is the convergence of practices. Try to have more convergence in the way we apply our common laws. So the cooperation fund, basically created in 2010, it's a cooperation program that has a budget of 50 million euros. All national offices from all the member states of the European Union participate, plus 11 user associations, because it does not make sense to create tools that then users would not be able or would not consider fit for purpose. So they are involved in the constructions of the tools. But also two other important international organizations, WIPO on the one hand, and the EPO on the other one. Also, various directorate generals of the commissions are involved here, such as DG Mark, but other. All in all, more than 300 people are working on a daily basis in creating these tools. The objective to create these 22 IT tools, databases, plus e-business tools that cover the whole life cycle of a trademark and a design that will contribute to modernize national offices and enhance user interaction with OHIM and national offices, improving coherence, consistency, and predictability. Because before we have launched this huge program, we have launched a consultation asking users what would be the most important tools that they would like to see us using and the national offices. And the results are the ones that have been created under the Cooperation Fund. Examples, Trademark View, which is the biggest trademark database online and free of charge in the world. It has 23 million trademarks, also coming from the US. All the US register is there. But we have all in all 35 countries, not only the EU, not only US, but we have 35 countries in 25 languages. You can, of course, search in different languages, European and non-European languages. Also, with business tools that will allow users to interact in a more user-friendly way with national offices when applying for protection for the results of the investments in innovation within also the national authorities. The second one, it's the Convergence program, Convergence of Practice. The objective here is to apply the law in a consistent and coherent way between national offices and the OHIM, and also between national offices. There are still unnecessary differences in this area. So we have the same law, but when we apply the law, we do it in a divergent way. And this, of course, represents a cost for the user, an unnecessary cost for the user. And we should make sure that we apply it in a consistent way. An example of what was achieved already, for instance, after the IP translator case, an agreement on class headings, on taxonomy, which is a way of navigating through our goods and services harmonized database, and also on acceptability rules for terms of the class headings to be accepted or not in the national offices. What we have today is that these national offices, they take a similar approach when dealing with goods and services scope of protection. You can debate if it's good or bad. What is important for us is that we all take the same direction. The foregoing clearly shows that the building of the network implies a colossal effort in terms of coordination, time, and funding. But building the network is not only about resources. First and foremost, the network requires solid foundations, and this can only be provided by a clear legal basis in the regulations. Secondly, it needs an harmonized legal framework based on common substantive provisions, which can support online examination standards and on streamlined procedural rules, which in turn will allow for the development of aligned processes and the use of interconnected tools and platforms. And this structure is, of course, viable only if sustainable financing is made. Only this way we can arrive at the desired aim, which is enhanced usability, transparency for users, and predictability for users, as well as increased procedural efficiency and legal certainty. And here is where the legislative review becomes particularly relevant, because it touches upon these very issues. The first provision worth mentioning in this regard is Article 123b, which lays down in paragraph 1c a clear legal basis for the office to participate in cooperation activities. Equally important in this sense is the reference in paragraph 2 to the cooperation with non-governmental organizations, that is to say, with user associations, which can be seen as a way of formalizing the participation of user associations in these cooperation schemes. The main provision, though, dealing with cooperation and convergence is Article 123c, In terms of architecture, this provision covers three aspects of fundamental importance. The areas of cooperation, which are expressed in a reasonably broad manner, allowing us for a flexible application. The form of cooperation, and here we talk about project-based model, led by the office, and the details of the funding mechanism. Articles 123b and c are complemented by Articles 52 and 53 of the Trademark Directive. It is again interesting to note that national offices must cooperate with each other and the OHIM in order, first, to promote convergence of practices and tools, and second, to achieve coherent results in the examination of trademarks. Again, it's the mirroring effect that we are looking for here. Ladies and gentlemen, to conclude, well, in our view, in our operational view of the proposal, the technical proposals put forward by the European Commission, they contribute, in fact, to modernize the trademark systems in Europe. But they also contribute to enhance usability, transparency, and predictability to users, because in the end, this is the main goal. This is the major goal of the reform. The strengthening of the network is one of the essential features of the proposal, and the reforms creates a formal basis for cooperation, defines the area of convergence, and secures resources. These three elements are fundamental if we want to continue in this path. By imposing a quasi-assimilation of substantive rules and a substantial alignment of procedures, it also provides for a clear framework for effective and efficient cooperation. All in all, we think that it goes in the way of evolution in the right way. And let me just take this opportunity to praise the work, because we are talking about a major package. We are talking about the revision of a regulation, a trademark directive, and an adjustment of the fee structure. And the work that was done by the European Commission, the European Parliament, and the Council should be praised here. And of course, we are convinced that in the end, the trademark system in Europe will be, of course, stronger than it is today. Thank you very much for your kind attention. Thank you.
We're now, having heard from João, we're going to hear from brand owners, and we're going to do this a little bit differently. We're going to be covering, with the two brand owners here, some of the key aspects that we think in a kind of more discussion-based format. And we will have time for questions at the end. But if you have anything that comes to mind while we're covering each of these topics that you want to ask straight away, do put your hand up. Already putting their hand up. We'll get a microphone to you. Question straight away before we started. How about that?
Hi, it's for Michael. It's with regard to the triggering date. I was just wondering, are you referring to the priority date when you're actually talking about triggering date?
Sorry,
Are you referring to the priority date when you're mentioning triggering date in your presentation?
Yes, exactly. I mean, we now really propose some sort of harmonized rules on what should, for example, also be the requirements for actually receiving the sort of priority date, where there's also some divergence in the different countries. So it's really about concretely these type of dates and times.
Okay. Continuation to my question was that in case of conflict, which date should be prevailing, the national date or the community trademark registration date?
Well, I don't think that it's a question of what takes priority, because for each situation you have to apply the law on where the registration took place. So if you have let's say a perceived conflict between a national and a European one, you have to take into account the specific rules that were sort of guiding the registration in the different systems. So it's not a question of one priming the other. It's more at the moment that in different countries, this date links to different events and is not harmonized the same way. In each of the systems, you come to a date. Yeah, today. That's not the problem. I mean, you come to a date.
What he might be saying is if you came to a date
using different rules in, for example, Germany and in the CTM, right? Which one takes priority? That's your question, right? You understand that there's also this issue that the different countries use different rules for how to establish priority than the CTM or each other, right? But what about this question he's asking, a little bit off topic, but still interesting to him, which is what takes priority, CTM or German registration?
I think I still don't see exactly the point there, whether you have, I mean, are we talking about parallel registrations of the same mark nationally and at the CTM level? Because again, I mean, for each mark that sort of is opposing or you compare, you can determine the date in the individual system. And then you see which one has a priority or not, which was the earlier one according to the systems. So I don't know, maybe the users want to, or João, you want to add on that, if I wasn't too clear.
Yeah, we're going to, we perhaps can deal with that at the end, but for now we're going to hear from our brand owners. So I'm going to start, one of the changes proposed obviously is the classification of goods and services. I would say that's more a clarification of where we are now following IP Translator. Gabrielle, what's your view on this aspect of the changes?
I would like first just to take the opportunity to just express in general as a brand owner our position on the proposal. And it's three different ones. We have from the Commission, we have from the Parliament, and there is also a report from the Council. So there are some things in each that we think are good, some things perhaps in some other ones that are not so good. But in general, I would say that we are very positive to this trademark package. And I'm talking for myself as a brand owner of IKEA, but also I have met in this process a lot of other brand owners and also other user and brand owners organizations. So I would say that we have a quite good consensus. Harmonization is very welcome. We also feel that it's evolution, not revolution. Things are working rather well today, but harmonization is definitely needed. What is very good is the cooperation between the national offices and OHIM. We see that it works very well today in the Cooperation Fund and the Convergence of Practices. And in the proposal, this is, as we see it, continuous cooperation in the form that is currently done today in the Cooperation Fund. So we think that is a positive thing. And also that the funding of the, when using the surplus or the fees that OHIM shall fund these projects, it's very good that it's made in a form of a grant and that it's tied to the project specifically so that we know that the money that are actually paid by brand owners are used for the benefit of trademark throughout the European Union. We're also very happy to see that users are specifically mentioned to take part in the projects, and also that convergence of practices is one focus area that is particularly mentioned as one of the ambitions. I just would like to conclude these general reflections by saying that we think that it's very good, of course, I promote very much a stronger IP agency. However, I feel that other IP rights should not be funded by trademark money. I think it's really important as a brand owner, and in particular now in the trademark area, that the money that the brand owners are paying are actually used in the best way for the trademark owners and not for other IP rights. And then if you look specifically into the class headings and the goods and service classifications issues, I think it's very welcome that it's now in the legislation, because the IP translation case, as I think you're all familiar with, really created uncertainty. And just talking for ourselves, we have mostly class headings because since we have so many, IKEA is registered for a very broad range of products, so where we can, we go for class headings. So I think it has been rather uncertain for brand owners after this, the IP translator case. We certainly welcome that. There is also a possibility for brand owners to specify, like in our case, if we have class headings, to go in and specify what kind of product and services we want to do. So everybody, if it was filed before June 22nd, 2012, brand owners can go in and make specifications. However, I think that the original proposal was 4 months, a 4-month period, which by the Parliament has been extended to 6 months. I still think that is quite a short period personally. I would rather see a year, because it takes, we have quite a few trademarks, and as I said, we are in most of them are in class headings. So I think we have a big work to do. So I would prefer some more time for that. I don't know if you have anything to add, Elena.
Yes, to second Gabrielle, first, in general, as many of the brand owners that are here today, Microsoft has been and is a substantial, and I could say avid user of the European trademark system, both at the national and the community trademark level. And we would certainly agree that the system has been a clear success in its dual nature. That said, we do welcome all the Commission's efforts and the Parliament and Council's work until today in finding ways to modernize and harmonize, further harmonize the system in order to ensure that the needs of the users of the system are better met today and in the future. And we therefore welcome most of the proposed changes and amendments that were put forward by both the Commission and some of the Parliament's amendments. And just to give a few examples, what was mentioned in the previous presentations, the removal of the graphic representability requirement, and instead the mention of use of available technology, an introduction of a sort of form of bad faith filing ground for oppositions of community trademarks, albeit a limited one. The further harmonization between the national systems and the EU system, in particular in relation to oppositions and ex officio actions. And the adoption of the literal meaning approach, which essentially codifying the IP translator decision and clarifying its application from a retroactivity perspective. And in that perspective, I guess as a U.S. company, we view it from a different approach. I'm an Italian trademark attorney, so I very well understand the use and of the class headings. But as a U.S. company, most of our filings are because we have to show use in our home country. The Microsoft filings are quite narrow to the goods and services where we have an actual intention or are using the trademark. Therefore, even in jurisdictions that don't require a showing of use in order to obtain a registration, we generally never use a class heading. We've not used a class heading approach. The other issue that we found, which I would like to touch on later, and might be a bit controversial for brand owners, but is the problem that as a company trying to always find new names for a variety of new products, features, and services, is the existence of so many unused trademarks on the European registers, both at the national level and at the community trademark level. And an adoption and an application of a class heading rule, we think definitely helped in increasing the situation of clutter on the registers. And that is because if I'm a trademark owner in the European Union, I can file in a certain class, say the class of interest to Microsoft very often is class 9 for software and hardware, and by just adopting the class heading, so not making even in terms of time and resources, I don't have to go and decide what narrow description of goods I actually want. I just use the class heading, and for 5 years following the registration, I have protection for anything that falls within that class. It evidently does incentivate people to and applicants, like it would, to actually create a situation where perhaps there's no real intention to use the mark for sunglasses, but because they fall within class 9, they would be covered for 5 years. So we very much welcome the literal meaning approach within the legislation, we did have a concern with the Commission's proposals in terms of filing the declarations and what would happen when the new amended description of goods, as opposed to later trademarks that were filed and registered possibly, but after the before the IP translator decision. And I noticed that the Parliament's draft that were voted actually include some provisions that would reduce the risk, because basically for those who, say for example, Gabrielle, you would amend and file a declaration and declaring what you had intended to cover with one particular registration, if my use of the mark based on a literal meaning approach would not have infringed yours, then you cannot come back to me now because you've amended it and say, now I've said that it's all goods in that class and therefore there's an infringement. So we welcome that as well.
One of the other perhaps most debated, certainly politically debated issues is relates to trade in counterfeit goods. Elena, perhaps you'd like to speak a little to that topic.
Yes, I'll try to be very quick because I understand we only have a few minutes. And as you heard from Cecilia Wikström and as both Michael and João mentioned, some of the very highly politically debated measures were those related to trade and counterfeits, and in particular the goods in transit provision, which as Microsoft we generally welcome. We obviously suffer from counterfeiting and piracy situations. There is an increasing concern with counterfeiters using an alleged declaration that their goods are in transit and therefore not destined for the European Union market to actually then just make these goods enter the market. So we were very welcoming of their proposal. We did have, however, some concerns of it being potentially too broad, and we could think of hypotheticals where even as Microsoft we'd have rights, say, and I'm really making up a hypothetical, we have registered rights in China, and registered rights in Brazil, but we don't have them in the European Union because of a conflict. We want to send our goods and ship them from China to Brazil. Maybe the best route is to go through Rotterdam and Amsterdam, and those goods in transit would effectively could be stopped by the rights owner in the European Union. So we have expressed those concerns ultimately between having no goods in transit provision and having a goods in transit provision that is overly broad or potentially could be applied in a broad manner. We prefer having the goods in transit provision, but our concern still stays in play. The other very debated, and I guess in the more recent months, a very debated provision was that of small consignments that you heard Cecilia Wikström mention. And that is because the European Union has a EU-wide regional exhaustion, and it is a fundamental principle of the legislation, and until now there has not been a successful change in the regional exhaustion principle. So under this system, a trademark owner can stop any goods from being imported from outside of the European Union when they were not put in the European Union by the trademark owner or with his or her consent. The provision that is proposed by the Commission basically, in my opinion, clarifies the trademark owner's right to stop, even though whoever is importing the goods is not doing so for commercial purposes. So because it's only the shipper or the manufacturer, where the goods originate from, is acting for commercial purposes. Now, the limitation that the Parliament is proposing and has voted, which would limit it to only counterfeits, not only would stop theoretically and limit the actual rights that the trademark owner has currently under EU legislation in relation to these individual small consignments, but potentially could be viewed also to limiting to other types of infringements that would not fall within the definition of counterfeit. Say, for example, that Microsoft is being placed on toothbrushes. Now, I don't know why you would want to, but they might want to put toothbrushes with Microsoft that type of import would potentially not constitute a counterfeit because we don't have registrations for toothbrushes. And there we would have an infringement claim based on our reputation potentially, but that we wouldn't be able to stop that type of importation by individuals. So those, I think, are the two main debated enforcement provisions.
I'm just going to touch on one more issue, which I think is another. Cecilia used the word hot potato, so I'm going to use that word as well, which is fees, less of a hot potato, but also the OHIM, or soon-to-be agency surplus.
Yes, I would like just to add that, as you said, there are the two issues. The surplus that is, I think, now above 500 million euro, that is just sitting there. And the question is what to do with that one. And then there is the fee system that is now revised, but if you look into the OHIM's budget for the next 4 or 5 years, you will see that there is an expected increase in trademark registrations and also community design registrations. So it means that the income will increase. There are 3 different proposals. One is that 10% of OHIM's income should go to the projects with the national offices. That is from the Commission. There is one proposal from the Parliament that 20% of the income should go. And then the third one from the Council is 20% of the income, or rather I should say up to 20% of the income, or 50% of the renewal fees. 50% of the renewal fees, the users have always disputed and said we do not want that. We don't want just some fees going to national offices without having any kind of control what they are used for. And some national offices don't even have their own budget, so the money could risk just going into other projects that the government are having. If you look at the amount involved here, so 20% of the renewal fees should equal something like 50 million euro, I think, a year. The cooperation fund has existed for almost now 5 years, and that is 50 million euro. It means that we should have one cooperation fund every year, and I wonder just how long can this continue? I mean, there must be at some stage there are not more tools or practices that could be developed, I assume. And the user have always, all the time, called for lowering the renewal fees because, as Etienne said this morning, it's not very logical that the renewal fees are like 300-400 euros more than an application fee when it just is a click to renew. And then the surplus, I mean, there is also a lot of debates going on what to do with that, all from giving it back to the users, which of course would be nice. I don't know if it's possible. But also to use it in different for different projects. And I think since there is at least 300 million euro, because there is a suggestion of 200 million that should be staying with OHIM for covering potential future costs, there is still a lot of money that could be used, which really makes room for even lowering the fee further. As the proposal is today by the Parliament, the fees are in the legislation, which I think makes it very inflexible. And there was an old suggestion of having a biannual revision of the fees. That will not now be possible, of course, because we cannot have this kind of legislative changes every other year. So to make it more flexible, I think as a user, I would rather see it outside of the legislation so that it can, because I think it will be necessary to decrease the fees in the future even further.
Okay. Time for questions. We've got about 5 minutes. João.
My question is to Mr. Michael König, and it's about goods in transit. You said that the Commission's view was that we should have a strong and effective tool to fight against counterfeit goods in transit. Your words echo those of your colleague, Mr. Thomas Eichenberg, who said the same thing at the ECTA conference in Bucharest last year. And he said also that the Commission had taken very strong legal advice about whether its proposals are in conformity with TRIPS and GATT. So my question is, how disappointed are you that the European Parliament has inserted the introductory words in Article 9.5 of the Community Trademark Regulation, which read, without prejudice to World Trade Organization rules, in particular Article 5 of GATT on freedom of transit, and the creation thereby of uncertainty as to the effect of the new provisions in relation to goods in transit? And how do you think it's going to be possible for these words to be removed ultimately from the legislation?
Yeah, thank you very much. First of all, I can again confirm that we are firmly convinced that what we proposed is compatible with WTO rules and GATT. And we have plenty of trade experts in the Commission to assess. And by the way, I mean, this type of provision and rule also exists in other GATT members. So I think that's saying that. Now, I'm not disappointed at all that this provision is there. I'm rather very happy that the Parliament actually went back to basically the Commission's proposal and did not follow Mrs. Wikström's proposal, which in our view would have been a step back. And we read this insertion of these words rather as declaratory, as being a reassurance for those who did not think that or who had still doubts that this is just an affirmation, because if you would see it as a condition, then indeed this rule would become, I would also say, impracticable, because if in the application of a very wide rule, you would have to consider where are the boundaries, and the boundaries are set in other provisions, and it could be that in execution of this of the provision as it is in, like in really preventing the rules from transiting, there could be an interference. I think this is really would be a circular type of exercise. So for us, this insertion can only make sense if it is purely declaratory, as it is also in the recitals stated, that this should not prevent the transit of medicines, which for us also is obvious and does not sort of limit the scope of this provision, which for us is targeting a completely different issue and is not related to mostly patent-related issues as regards generic medicines and their transit. So that's our reading of this insertion. Now, of course, you know, if the wording is removed, then it for us doesn't change really a lot if you apply this reading. I would expect that at least some sort of this wording you will find at least in the recitals, in the explanatory elements. But I think the choice and the responsibility that the legislator has to take is to say, yes, if we have such a rule of preventing transit of these goods, we believe it's not an interference, and we're ready to apply it in the Union. If there are doubts and people hesitate, then it's not by putting a general caveat in a wide rule. Then you have to change the rule if you don't have the conviction that it is actually compatible. We are convinced that it's compatible, and that's why we believe the wide rule as it is, without any caveats, can work.
Okay, thanks. We've got time for one more short question.
As Michael presented, there has been some kind of incorporation of recent jurisprudence like the IP translator case into the new proposals. What do the practitioners, so Gabrielle and Elena, think? Is this sufficient, or should other settled case law, for example, settled case law of the CJU on composite trademarks be incorporated in the directive and regulations? Because there has been some inconsistencies in the member states.
Just very high level, I would, and this is my personal perspective, I would try to avoid the too much integration of case law and jurisprudence within the legislation. Many of the decisions taken by the Court of Justice, whether the General Court or the Court of Justice, are very factually based. They are on a case by case, and there is always a risk of trying to take one situation and making it a general rule. The IP translator was a very welcome and needed decision because of the various inconsistencies among the national offices and the OHIM. I honestly, off the top of my head, I wouldn't see personally any other of the present and current jurisprudence with a need to codify it into the legislation.
Great. Thank you. Thanks to all the panel. And thanks, Cornelia. Thank you very much. Sorry we were kind of a bit short.